The amendments that I'm now seeking to move in my name and Senator Fawcett's name, I will loosely and colloquially group together under the title of Freedom Amendments, and that is because, in aggregate, their main intent is to protect the freedoms of Australians while legislating for same-sex marriage. There are a number of provisions in these amendments, not all of which I will seek to speak to, but I will seek to speak to the major ones in it, and I'm going to single out three in particular that I think are worthy of the Senate's attention and support. The first is on freedom of speech, the second is on anti-detriment, and the third is on parental rights. The amendment to protect free speech is listed under 88J, and this is, in my view, perhaps the most important amendment that the Senate will consider today to this bill. And the reason why I believe it's so important is that freedom of speech is the most fundamental freedom we possess as Australians and free citizens of a free country like Australia. Without free speech, we have no ability to fight for, to argue for, to seek to protect our other rights. Every other right we hold depends in part on our ability to speak freely about why we deserve them as individuals. Freedom of speech can and has been affected by the same-sex marriage debate in a couple of ways. One, it's been a very important part of the successful campaign to lead to a change in the law to allow same-sex couples to marry. If it wasn't for the freedom to speak, then campaigners who sought to change the law for many years in this country to allow same-sex couples to marry would have had no means to argue in favour of it. And I think it's a perfect demonstration of the value and the virtues of free speech. People who once held an opinion in Australia that was a minority opinion or an unpopular opinion were able to make arguments in favour of their view, to persuade their fellow Australians to agree, and ultimately that was confirmed as well as it could ever be confirmed in the postal marriage survey, with a strong majority vote to change the law to allow same-sex marriage to become legal in Australia. I want that freedom of speech to be preserved for those people, and I also want it to be preserved for anyone who has a different view, particularly anyone who thinks that the traditional definition of marriage is the definition which they choose to believe is relevant to them. And this amendment ensures that that will be the case. If these amendments are not successful, it will not be clear that Australians have the freedom to speak about their views about marriage. Only passing these amendments ensures that that's the case. One of the important things about these free speech amendments is that they quite deliberately set aside state anti-discrimination law, which restricts freedom of speech. And I'm going to talk about one state's law in this area in particular because it is particularly egregious and it has already been used to the detriment of this free debate on this issue, and that is Tasmania's anti-discrimination law. In many ways, it is modelled on the federal legislation under 18C, which prevents conduct which offends, insults, humiliates or intimidates someone on the basis of their race, but it goes further. It incorporates as a protected attribute not just race, as the Federal Act does, but many other attributes, including gender and sexual preference. What that means is that speech in Tasmania which offends someone on the basis of their gender or their sexuality is speech which is unlawful in the state of Tasmania. There's been one case already that's been taken to the Anti-Discrimination Commissioner in this area, and that was the case against Catholic Archbishop Julian Porteous. Archbishop Porteous circulated a document to his parishioners which stated the Catholic Church's view on marriage. Now, as someone who voted yes in the survey and believes in same-sex marriage, it did not reflect my views, but I think I can say quite fairly that it was a mild-mannered expression of the Catholic Church's view on marriage. It was a fairly modestly and carefully expressed view about why the Catholic Church believes what it believes. Someone took offence to the existence of this document and its circulation to Catholic parishioners and made a complaint under this Tasmanian law about this booklet, and that complaint was accepted by the Anti-Discrimination Commission, and it entered into the first phase, which is the investigation and conciliation phase of the anti-discrimination law in Tasmania. Now, after being in that stage for many months, and after the Catholic Church in particular accruing tens of thousands of dollars of legal fees in order to defend itself or to prepare to defend itself in this case, the complaint was withdrawn. Some people have taken comfort from the fact that this complaint was withdrawn, and in a sense I guess it is a good thing that it didn't proceed to court, because having it proceeding to court would have been a troubling thing for free speech. But I don't share that same comfort that others do, because the withdrawal of the complaint means it's now legally uncertain in the state of Tasmania whether a booklet such as Archbishop Porteous's would be legal to distribute or not. The Commission never ruled on it, it was never taken to court, and the court never ruled on it. So right now today, the best we can say is in Tasmania it is legally unclear if you can freely speak about your view about marriage. But there are 2 further cases before the Anti-Discrimination Commission under the same law for similar reasons right now. They are against a Presbyterian preacher, Campbell Markham, and David G, who is known as a street preacher, who made similar comments about same-sex marriage and homosexuality. Now, I stress again that those comments that they made do not reflect my views, but I believe in a free society they should be able to share their views. Now, their complaints are now again before the Anti-Discrimination Commission, or a complaint made against them, sorry, is before the Anti-Discrimination Commission. Again, we don't know where that case will land, but it is possible that the Anti-Discrimination Commission and subsequently courts will find that their speech was not lawful. I think it's urgent that we need to clarify this issue. If 2 complaints against 3 people have been made, while the law of the land is that same-sex marriage is between a man and a woman, imagine how many more cases will soon flow after the law changes at a federal level to allow same-sex couples to marry. There will be people who will take the view, now that the law federally is same-sex couples can marry, that people continuing to argue for a traditional definition of marriage are in some way flouting the law and should be taken to a commission or to the courts to resolve that. I do not want to see that happen. So this bill protects the free speech of those people to share their views about marriage, and it sets aside any state laws which restrict their ability to speak freely on this issue. But importantly, it doesn't do so in an unlimited way. It only does so relevant to their marriage beliefs and associated beliefs about marriage. It does not do it on any issue under the sun, just about marriage, because that's what this bill is about. And it also doesn't do so in an unlimited way in terms of what can be said. If the conduct is threatening or harassing, there will be no protection from state laws. State laws will continue to apply as they have applied previously. So this is not a get-out-of-jail-free card. This is not a carte blanche. You cannot say anything you like. You must say it within reasonable bounds. That is the free speech amendment, which I think is particularly important. I want to briefly talk about the other 2 aspects of this bill that I think are worth particularly highlighting. The second is the anti-detriment provision. It's number 88K in the amendment. What this amendment seeks to do is ensure that people who continue to hold a traditional view of marriage after the law changes cannot have any detrimental action taken against them, and it particularly seeks to do so by public authorities and agents of public authorities, because I think we all agree that whatever we decide to do in our own free lives and with our own time and our own money, that is one issue. But taxpayer-funded organisations and bodies empowered by the state have a special obligation to treat all Australians equally and not to adversely treat them. Effectively, what this anti-detriment provision does is replicate what already exists at the state and federal level in most states in terms of protections for people based on their sexuality or their gender. It is already unlawful to mistreat someone based on their sexuality or gender, as it should be, but it is not unlawful to mistreat someone based on their traditional belief in marriage, and I think it should be. I think they deserve equal protection. That's effectively what this amendment seeks to do. One of the practical issues that this amendment seeks to deal with is the case of a body which is empowered by the state to licence an occupation to allow people to practice their profession. This is not a theoretical provision, but it's a very real provision, meaning a very real need. We saw during the postal survey a petition hosted on a website managed by GetUp, which sought to revoke the registration of a doctor, Dr Pansy Lai, who had appeared in a Coalition for Marriage advertisement explaining her view by marriage should remain in the traditional sense between a man and a woman. Now, this petition said that she should not be allowed to practice her profession as a doctor simply because of a political view she held on a political issue, not because she was unfit to be a medical doctor in any other sense. Presumably whoever started the petition had no way of knowing that. All the petitioner knew was that this doctor believed in a traditional version of marriage, and he thought that was sufficient grounds for her marriage license, so for her doctor's licence to be revoked. It attracted a number of signatures and support before GetUp wisely removed the petition from the website. But what it shows is that there are some people in Australia who think it's appropriate to deny people their ability to practice their profession based on their political views. So I think those people deserve protection. If any doctor is incompetent or unable to fulfil their duties, they of course should have their licence to practice as a doctor removed, but they should not have it removed solely because they have a traditional belief in marriage. Overseas, we've seen similar cases. Trinity Western University in Canada is a Christian university that has traditional views about marriage and sexuality, and it requires that its students uphold those views. And in some provinces in Canada, the registration of its graduates, in terms of their teachers and the lawyers, were denied by state authorities simply because they attended a university that had a traditional view of marriage and morality. That is an extraordinary thing, that graduates from a university could be denied the opportunity to practice their profession based on the views of a university they attended, not even their own views, although I also think their own views in a non-relevant way should not be considered. So this anti-detriment provision is dealing with a very real issue. It deals with some other issues, but given the time, I won't go into more detail about that. I suspect other senators will make contributions about that. Finally, I want to single out one further significant part of this amendment, which is under section 88R of the amendment, and that is parental rights. Parents in Australia already very clearly have the right to remove their child from a class where that teaching is about religion or religious instruction. It's a right that many parents take up. I remember when I was in primary school and religious instruction teachers came to teach us about the Bible and Christianity, it was an option for my parents and other parents to ask for their child to be removed from the class, and some children and parents chose to do so. And I understand today, at least in my home state of Victoria, in public schools, a very high proportion of students take up that option and don't attend those classes, as they should. In a public school in particular, if a parent and a student does not have religious faith or is not interested in learning about religious faith, they should have the option to not attend a religious instruction or religious education class. What is not clear is whether parents who have a traditional view of marriage, traditional view of morality and sexual ethics, for example, has the same equivalent right to remove their child from a class if the teaching is inconsistent with their values. Again, this is not a theoretical amendment meeting some kind of theoretical need. It's a practical amendment meeting a practical need, because at least in my home state of Victoria and to varying degrees around Australia, there are programs such as the Safe Schools program which teach very radical ideas about gender and sexuality, and no doubt marriage and perhaps even more in due course, in a way that many parents do not accept for religious reasons or purely secular reasons. And I think those parents and those students should have a right to decline to participate in those classes. They should have a right to step out of that class. Now, it's already been suggested in this debate that this may lead to, for example, a Christian parent withdrawing their child from a science class because it teaches creationism. As ridiculous as that suggestion is, this has been carefully drafted to ensure that that would not be an option, that could not be taken up. The only instance where a parent could remove their child from a class beyond the rights that they already have is when that teaching is inconsistent with their views about marriage. So if a parent or a family holds a traditional view of marriage, they should be able to remove their child from a class where that teaching is being taught. So it's not again, it's a narrow-focused amendment for a narrow-focused reason. It is not a carte blanche. It is not a right to remove your child under all circumstances. That is not an exhaustive list of all of the amendments, all the provisions of this amendment, but it is the three that I think are most significant: freedom of speech, anti-detriment and parental rights. I suspect other senators will highlight different parts, and I, of course, will be happy to engage in the committee discussion as we go forward on any other parts of it.